The decision is now in. The Judicial Commission of Pakistan has approved by a majority the transfer of 3 judges of the Islamabad High Court, Justice Mohsin Akhtar Kiani to the Lahore High Court, Justice Babar Sattar to the Peshawar High Court, and Justice Saman Rafat Imtiaz to the Sindh High Court. 2 other proposed transfers were withdrawn during the meeting. The Commission has also decided that any vacancies created through these transfers will be filled through further transfers, not fresh appointments. This is the outcome. Now, the question is what it means. On the surface, this is a constitutional process playing out exactly as the law allows. Article 200 permits the transfer of judges from one high court to another. The Judicial Commission has met, it has voted, a majority has approved the transfers, the mechanism has worked. But the story does not end with legality, it begins there. To understand why this has become controversial, you have to look at what has changed in the law itself. For a long time, there was a clear understanding that a judge could not be transferred without his consent. That was the balance that existed within Article 200. The power to transfer was there, but it was not absolute. That balance has now shifted after the 26th and 27th Constitutional Amendment. The Judicial Commission can now recommend a transfer even if a judge does not agree, and refusal can lead to proceedings under Article 209. So the law has moved in a very clear direction, from consent towards authority. Now look at the body that made this decision. The Judicial Commission of Pakistan today is not what it used to be. It is a 13-member body where 5 members come from the judiciary, including the Chief Justice and senior Supreme Court judges. But the rest come from outside the judiciary: the Law Minister, the Attorney General, members of the Parliament from both Treasury and opposition benches, and nominees from the bar and other categories. So this is no longer a purely judicial forum. It is a mixed forum, and that changes the nature of the decision. Once you see that, the numbers begin to matter. 13 members, 7 votes decide, which means that decisions here are no longer shaped by judges alone. They are shaped by alignments across institutions. That may be entirely constitutional. Parliament has passed the amendments, the structure exists in law, but it inevitably introduces a new dimension into how such decisions are understood. And that brings us to the central tension in this story: legality versus intent. Legally, there is very little ambiguity. The Constitution has been amended, the process exists. The Commission has the authority. A majority has approved the transfers. Each step follows the law as it stands today. But legality does not answer every question. Intent sits alongside it. And intent is not written in the text of the Constitution. It is read through context, through timing, and through the nature of the decision itself. That is why the reaction has been so divided. Within the legal community, there are those who say this is a legitimate exercise of constitutional power and that institutions must function within the framework defined by the Parliament. There are others who warn that it sets a precedent where the power to transfer, even if lawful, could begin to shape judicial independence in ways that are not immediately visible but could become significant over time. The Chief Justice of Pakistan has himself expressed concern along those lines, warning that such transfers could create a perception that judges are interchangeable, and that once such a perception takes hold, confidence in the system begins to shift. At the same time, the law as it stands today does not give him the ability to block the process on his own. The Commission decides, and if it has the numbers, the decision stands. So this is where we are tonight. A decision has been taken. A legal process has been followed. A constitutional mechanism has been used. But a larger question remains. This is not just about where these judges will now sit. It is about how decisions about judges are made. Because once you change the mechanism, you change the balance. And once the balance changes, the institution itself begins to look different. So the real question tonight is not whether these transfers are valid. They are. The question is what it means that they are now possible in this way. And that is the question this decision leaves behind. So, of course, the big decision is here, as I was talking about earlier, that the Supreme Court of Pakistan has also now officially intimated the decisions. Three honorable judges have been transferred from the Islamabad High Court, and two others will remain where they are. To discuss this further and to try and understand the impact of this decision, I'm joined by two very senior and respected lawyers. Mr. Shah Khawar is here with us, a prominent advocate of the Supreme Court of Pakistan and former Additional Attorney General and former chairman of the PCB Election Commission also. And Mr. Abdul Moiz Jafri, again, one of the most well-known lawyers of Pakistan as the head of chambers at AMJ Law. Very grateful to both of you. Shah Khawar Sahab, if I were to start with you, what's the big takeaway? What is your immediate feedback? Were you expecting all of this to happen? And what happens now?
Yes, Mr. Fahd, the discussion for the transfer of the judges of the Islamabad High Court was there since long, and ever since the 26th and 27th Amendment, which was brought in the Constitution, and especially in 27th Amendment when the amendment was made in Article 200 of the Constitution of Pakistan, which provides a procedure for the transfer of judges from one high court to another high court. In the previous Article 200, prior to the amendment, this was mandatory that in case a judge is to be transferred from one high court to the another high court, the consent of the concerned judge was mandatory. And not only the consent of the judge, but also judge of the respective high court where he is serving, and the concurrence of the high court where he is sought to be transferred. After this approvals, then the matter was to be given assent by the Chief Justice of Pakistan, and then the notification of transfer was approved by the President of Pakistan. So this was the previous arrangement. But after the amendment in Article 2000, according to 27th Amendment, now the mechanism has been totally changed. The consent of the judge is not mandatory, and the Judicial Commission of Pakistan has been given this mandate to recommend transfer of one judge from one high court to the another. And this first dispensation after this amendment has taken place. But this was quite obvious, and it was expected that these judges are going to be transferred. But there were 5 names initially recommended by the Chief Justice of the Islamabad High Court. And you know that when this proposal was given by the Chief Justice of the Islamabad High Court to the chairman of the Judicial Commission, who is the Chief Justice of Pakistan, he refused to act upon it. Then, according to the procedure provided in the present Article 200, if the 1/3 of the members of the Judicial Commission, if make a requisition,
Yes.
Then this Judicial Commission could assemble. And this was the case that today's meeting was requisitions by almost 5 or 6 members
Mr.
of the
Shah,
Judicial Commission.
There is a problem right there. You mentioned the Chief Justice of Pakistan giving, not agreeing to this and giving a written order saying that this was the wrong move. Him having said so, despite the fact that he doesn't command them, it does in some ways rob this decision of its moral value when even the Chief Justice of the country is not agreeing to it.
Yes, this is very important. And one important aspect of the matter is that the Honorable Chief Justice also wrote a note in which he expressed his dissatisfaction over this proposed transfers of the judges because he was of the firm opinion that according to the Islamabad High Court rules 2010, the Islamabad High Court judges will be appointed from all provinces, and all provinces and other areas of Pakistan will be given representation in the Islamabad High Court. So his viewpoint was, and that was very logical, that if 5 judges are transferred to the other provinces, then the federalism concept of the High Court will be diminished. And that is why he opposed this idea.
And
But
you agreed
since,
with that.
sorry,
You agreed with his logic.
yes, I agree with the logic. And I believe that is why when this Judicial Commission assembled today, there was proposal of 5
Yes. Let
transfers
me,
from the
Shah
Islamabad
Khawar
High
Sahab, let
Court.
me come back to that because I think that's a valid question. Why only 3 people were transferred? What happened? Clearly, there is some reason behind that. But let me just get Moiz Jafri Sahab also in the discussion. Moiz Sahab, your response to this. Obviously, no surprise this was happening. But now that this has happened, what will be its impact?
Look, I think that this is a preconceived move. It was the reason why the 26th Amendment was first attempted. The Islamabad High Court had become a thorn in the side of the executive. It had stopped the executive from using its heavy-handedness against the opposition parties. Back when Justice Atar Minullah first loaded it with independent voices, for which he toured the nation. He picked what he felt to be the brightest young talent. He gave them assurances that their jobs would be protected as far as he could protect them. It's sad that he himself isn't there anymore to be able to give voice to the farce that is happening today, but that is obviously another story. These transfers are also a stated intent, and they were crystallized. The intent behind them was further crystallized when 6 judges of this Islamabad High Court, out of a grand total of 7 at the time, wrote to the Supreme Judicial Council, the authority they felt was the only fit authority to address, and alleged that their Chief Justice was in collusion with the executive. And the executive here was a very diluted term. What they meant went far further, was coercing them and attempting to coerce them and get in the way of their independent judicial functions. Now, in response, direct response to that letter, we've had a lot of fire and fury and brimstone from Chief Justices, but nothing further beyond that. Our current Chief Justice has decided to ignore that matter completely. And the government felt so confident under the term of Mr. Justice Qazi Faiz Issa that they went so far as to say that they will initiate disciplinary proceedings against these people and try to get these judges and try to get to the bottom of it. Well, they've played a patient hand, and now they've gotten to a point where they can effectively discipline them. This amendment, regardless of how it was carried in the dead of night, regardless of how it was achieved without true consensus by a non-representative government under a cloud of an unfair election, regardless of all of that, the amendment in its words is against the core function of judicial independence. It eats at the basis of what is considered to be an independent judiciary, where you can affect the tenure of a judge, where you can affect the placement and position of a judge, where you can make a judge's work harder tomorrow because of what he does today. That in itself is a dampener on judicial independence. And what's happened here, Mr. Husain, is that without reasons being afforded, 3 judges known to be independent have been disturbed from the principal station where they took an oath to serve. They are being transferred under an article whose original state allowed transfers temporarily. The temporariness, the temporal nature of that transfer was evident in the body of the article itself, in the spirit endowed. That temporal nature has still not been done away with. There is a punitive aspect that has been added, whereby if you don't listen to the transfer now, you can be removed from office through the misconduct clauses. And what has also been added is that you may be transferred for any duration. And what has also been added is that you can be transferred without consent. But surely, when you move a civil servant from one station to another, you afford them reasons. Surely, reasons should be part of this decision. And that is also Mr. Yahya Afridi, Mr. Chief Justice Yahya Afridi, has been part of this backsliding of judicial independence. He's stayed silent until now, where his commentary is basically ineffective because his vote doesn't matter. But when he has spoken up, what he said is, all correct. It's a little too little, too late, but it is correct in that what are the reasons for this reshuffling of the deck? Why are you sending the only minority female voice back to the province when you brought her saying that you were enriching the federation in Saman Rifat Imtiaz?
Now,
why are you sending, and just if I could complete, Mr. Sen, the idea of transfer, the genesis of the idea was that there might be a judge with a specialization that a province might need at a particular point in time, or a case might be of such a proportion that you might need an independent person from outside the province to adjudicate. What comes to mind is perhaps an Omni Group investigation against President Zardari, which couldn't take place in Sindh. So instead of Saqib Nisar pulling it up and putting it to the Islamabad authorities, he could have also transferred a judge from Islamabad to Sindh to hear it. That is why the idea of transfer existed, and coupled with the consent of the transferee. With that taken away, judicial independence does not stand anymore, and with the reasons not being afforded, it is basically punishment. You are punishing a fine, independent mind. You are relegating him to a province to which he is alien without any reason being afforded.
Now,
And you have been saying you do this for years.
We have to take a short break here. Our discussion will continue, so do stay with us. The complicating factor here, Shah Khawar Saab, of course, what Moil Jafri Saab is saying is something that we've been very loudly and obviously holds a lot of merit. The counter argument that we've been hearing, and now, of course, after today's decision will also be repeated, is that this is the product of legislation. It is legal. The amendment was passed by 2/3 of the parliament. Therefore, it is the law of the land. And once that law is adopted, it has to be followed through. The other counter to that is that, well, if a law is considered not a good law, it can be challenged in court, and then the courts decide whether the law should hold or not. In this case, obviously, the courts have not picked it up for a number of reasons. So when this debate now intensifies more after today's judgment, which argument will hold more ground, you think, in today's context?
Yes, Mr. Fahd, Mr. Moiz has thrown light on one aspect of the matter. The other aspect of the matter is also there. So you must be remembering, and you just recall, that this controversy started when the 6 judges of the Islamabad High Court wrote letter to the Supreme Judicial Council, to all members of the Supreme Judicial Council, in which they leveled allegations on the apex intelligence agency, that the agency and their officials are pressurizing us and want to get results and judgments of their favor. So the problem started there. Writing letter to the Chief Justice of Pakistan or the Judicial Commission of Pakistan or Supreme Judicial Council, I believe, is no problem. But making that letter public, that invited a lot of hue and cry from the other side, and it became controversial. So what I believe is, being a student of law, because I have almost 35 years of my legal services in the 1 year in the bench also and in the bar, what I believe, being a student of law, is that the judges should not have opened that letter to public and leveling allegations on the security agencies. When they wrote letter to the Supreme Judicial Council, when they were called there and they were confronted with the situation that the judges had already powers under the Contempt of Court Ordinance 2003, that they can call and initiate contempt proceedings against any person, against any official, against any state functionary who causes any obstruction in the dispensation of justice. So that power was with them. Despite of exercising that power, they made that issue as public and highly controversial. I am not in agreement with all. I do not support whatever has been happened with the judiciary and what judiciary is facing now. This is very painful for me also. But the fact remains that, very unfortunately, the judges themselves exposed them to this treatment, and I believe they are fully involved in it.
Moisa, what happens now? Where do we go from here?
Look, firstly, in response to what my learned senior has said, is he effectively then agreeing that this is a punishment? Because if you wanted to punish these people for doing something you thought was improper, which is naming intelligence agencies for interfering with their work, then you should have proceeded against them in the article that relates to misconduct, abuse of office and misconduct under Section 209, but you haven't. You have instead proceeded against them after trying to proceed against them in misconduct, at least 2 of them. You have now tried to proceed to effect a transfer, which you are at every end trying to state is just a transfer without affording any reasons, and you are at pains to try and explain to lawyers such as I that it is not a punishment. But the only justification you can give of it is that, well, you're being punished for saying too much and you really shouldn't have. So that, that in itself kind of proves my point. As far as your question as to what now is concerned, well, we can only, the maximum we can do about it is to speak of it and to call it wrong. I think we are in dire straits, and I think we need to record it so that tomorrow it may perhaps be corrected. We must record the wrongs of today. I have no hope from this judiciary in being able to correct course internally. The time for that, to do that, has now passed. The champions of doing that have now resigned. I don't see too much hope from our senior judges being able to band together and undo this farce that is the 27th and 26th Amendment, not only in the method in which it was passed, as you suggested, but also in the numbers that were cobbled together to pass it. The characters that banded together, colluded together to cause such a travesty upon the Constitution will be exposed. It will take perhaps longer than I desire. It will take perhaps longer than I even know, but it will be exposed for one simple reason. You cannot have any concept of a democratic function without an independent judiciary. And no matter how poor we are as a democracy, no matter how ailing, if we want to face the world, it would be a different matter if there was oil coming out from under our feet and if we had 10 different wars to fight for the world and get paid for it. But until that is true, if we want to face the world and offer terms of trade, terms of investment, no one is interested in a country where the judiciary is a supplicant of the executive. The judiciary must be independent. This is a simply unsustainable arrangement, and until it is independent, these same people that have toyed and tinkered with it will tomorrow want it to show a basis, want it to show a seedling of independence, because without it, you cannot lay claim to being a democracy. And without laying claim to that democratic structure, a lot of what we claim as a democracy is also at peril, including several of our preferential deal agreements with the greater world, including Europe and America.
Shah Khawar Sahab, very briefly, I have only 30 seconds left. Where do we go from here? What happens now?
I believe that these amendments have been made in accordance with the procedure given in the Constitution. Yes, there are few amendments and few things which are not pleasant in nature. For me, this is not pleasant in nature, but since these amendments have been carried out by the Parliament with the 2/3 majority, we have to adhere to it. And with the passage of time, yes, I believe that a time may come when the older dispensation of the Constitution is reversed. It cannot be ruled out even.
Thank you very much, Shah Khawar Sahab and Moez Jafi Sahab, for joining me today to talk about this topic. That's the full frame for tonight. See you tomorrow.